I think one of the biggest misconceptions people have about medical malpractice lawsuits is that they might be a quick payday. I think they are incredibly challenging cases. I've worked in different areas of the law, and anything that involves medicine is very difficult. In these kinds of cases, there are different aspects that we have to prove. So we have standard of care, causation, damages, and within those heads of damages are different areas as well. And I think the complexity of all of that coming just together in a neat little package for the trier of fact takes a lot of time and dedication. And so telling your client's story is really challenging. And it's also challenging for the client, right? I think anyone who goes through the litigation process goes through a tremendous ordeal when they've already gone through one. It can be re-traumatizing, it can be challenging from a client perspective. And so I think the journey is a lot more difficult than people understand it to be. So when a medical malpractice case first comes in, I'm trying to understand what happened right away. And of course, we have the medical records and we have other documentation that can give us clues or can tell us a story. But I think it's important to go directly to your client and understand from them. Because often there, we have a lot of information that will fill gaps. So for example, in informed consent cases, there's often differing versions of events. And our client's story is incredibly important for us to be able to tell a compelling narrative about what happened or what should have happened. So from the moment I begin speaking to my client, the first thing I want to understand from their perspective, not from the contemporaneous record or for some other source, is what was it like that day? What were they feeling? What were they experiencing? And what happened when you were interacting with the healthcare provider? And what went wrong in your perspective? I try to support my clients during the litigation process by empowering them. Going through medical negligence litigation is something that is incredibly invasive. It is challenging, it can be re-traumatizing. And I think having them understand each step of the litigation process and empowering them to not only take our instructions or follow our lead, but to really understand why things are happening. So for example, at examinations for discovery, not only giving them guidance about how the day will go, but really having them understand the purpose of it and having them be able to kind of connect the dots is important because they feel like they're in control and this is about them. So that's how I try to empower them. Medical experts are crucial to medical negligence cases. We can't advance cases without them, or in usual cases we can't. They help us understand what the standards of practice dictate, what ought to have happened. And obviously as lawyers, we're not medically trained. A good medical expert will really walk you through every single aspect of the case within their wheelhouse in a way that helps you understand in simple terms what's gone wrong, what is a disease process, where should this have gone, and taking your time with experts and really having them explain it to you top to bottom and going back and asking questions, being curious about their responses. My approach is always to make sure that I'm asking every question that I can because they are the expert, right? They're the one teaching me about what the disease process is. When I walk into this firm, it really does kind of feel like home. And everyone is warm and supportive, and I think we're all pulling on the same rope. We're all trying to achieve the same thing, which is to help our clients succeed in their actions and to have their voices be heard. I think I'm working with genuine people here, and that's something that is very important to me.